Hello guys, my name is Anurag Roy from Law and Learning. Today in this video I will talk about Indian Evidence Act, the general introduction to the act, the definition clause that is section 3 and the presumption that is section 4. The general thing about Indian Evidence Act is there are in total section 167 and 3 parts and 11 chapters. We will deal with each and every section in coming videos related to Indian Evidence Act, but in this video I will just talk about general introduction, definition clause and presumption. So the first thing that you will came to know about Indian Evidence Act is that it applies to civil and criminal procedures as well, and that's the thing why it is so important. Indian Evidence Act play a very important role in both criminal and civil procedures. I am also making a series on Civil Procedure Code. If you are interested, check out the link that is provided in the description. I am also making a series on Indian Penal Code. The links are provided in the description. First thing before I start, I must tell you that it is the most technical act that you will learn, but it is the easiest one once you know the basics. The basics are the definitions. In the definition you will hear the words like fact, proof, disprove, relevancy of facts, fact in issue, and all kind of these words, and these words play a very important role as each and every section talks about these words only. Indian Evidence Act Chapter 1 Preliminary. Section 1 talks about short and title, very easy section. It just says that it extends to whole of India except the state of Jammu and Kashmir. It applies to all judicial proceedings such as criminal and civil, including court martial, but there are some courts martial that are not covered, like Army Act, Navy, Indian Navy Act. This act does not apply to affidavits and arbitration. Arbitration is basically an outside court settlement where both the two parties who are in dispute regarding any matter appoint a third party to become a judge and sort out their matter. So Indian Evidence Act does not apply to affidavits, it does not apply to arbitration, but apply to all judicial proceedings and applicable in India except state of Jammu and Kashmir. Section 2 is repealed. Section 3 is a definition clause. It play a very important role as it contains the definitions of basic words that you will hear in every section, and that make these definitions are very important, and it also helpful to understand each and every section with ease. So let's get started with the first definition, that is court. It just simply says that it includes all judges and magistrate and all persons that are authorized to take evidence. Now you know all judges and magistrate are included in court, but what about all persons? It basically a residuary word that covers every person who legally authorized to take evidence, like the members of Panchayati Raj. They can take evidence, they are authorized to take evidence. So in this case they are also included in the word all persons, and they are also a court. Let us come to second definition, that is a fact. Fact is very important and you will hear this word in every section. So let us start. It means and includes everything, state of thing and relation of thing capable of being perceived by senses. Any person who has sense and he perceives anything or state of thing or relation of things, that is a fact. And the mental condition of a person in conscious form is also a fact. Let us start with illustration. There are some of the illustration that simply says that if an object is arranged in a certain order in a certain place, it is a fact. If a man saw a thing or heard a thing, it is a fact. If a man said anything, it is a fact. If a man holds certain opinion or certain intention, acts in good faith or false against any person, it is also fact. Illustration D is an example of mental condition, that is subsection 2 of fact. E talks about that a man has a certain reputation is also a fact. Now let us come with relevant. Relevancy of fact or relevant is also a very important word that will play an important role, as it says that one fact if related to the other fact in such a way as provided under section 5 to 55 is a relevant fact. Fact in issue are those issues which are in fact to be decided by the court, as it says that any fact in connection with the other fact, the existence, legal or non-existence, nature, extent, liability or desirability or asserted denied in a suit or proceeding necessary follows. In simple language, when the liability right in a suit is asserted or denied is a fact in issue. If A is accused of B's murder, then these kind of fact in issue will arise as A caused B's death, A intended to cause B's death, or he has received a grave or sudden provocation from B. B's death is caused by unsound of mind or not. The definition of a document is very easy, as it just talk about any matter which is expressed or described by means of letter, figures and mark is called a document. In illustration you can see that a writing of a person is also a document. A word printed, lithograph or photograph is also a document. Map or plan is also a document. An inscription on a metallic plate or on a stone is also a document. Caricature is also a document. So these are the examples you can say of a document. Now come the definition of evidence. Evidence is of two types: oral evidence and documentary evidence. Oral evidence talk about any statement which is provided or permitted by the court to be made by a witness is oral evidence. And when we talk about documentary evidence, it includes documents and also includes electronic evidence like your mails, photographs, pics, that is in digital form. Now the definition of proved. It is also a very important definition, as anything can be said to be proved if the court believes that it exists, or there are certain situations where a man of prudent understanding suppose that it exists. In simple language, there are two things which is provided here: the court and prudent man. If these two believes that anything exists, then it is said to be proved. The definition of disproved is similar to the definition of proved, as here also two things: one is court and the other one is prudent man. When these both of these think that a certain thing does not exist, then is said to be disproved. Now not proved. The definition of not proved just very simple, and it says which is neither prove and nor disprove is said to be not prove. The definition of India is very simple. It just says it the territory of India except the state of Jammu and Kashmir. Now came a very important definition, that is may presume. Here we will talk about may presume, shall presume and conclusive proof. So let us start with this chart. Here you can see section 4 talks about presumption. Now presumption are of two types, presumption of law and presumption of fact. Presumption of law can be divided into two types, rebuttable presumption, irrebuttable presumption. Rebuttable presumption means that can be rebutted, that can be changed. Irrebuttable presumption is the presumption which cannot be changed by the court. Now rebuttable presumption is shall presume and irrebuttable presumption is conclusive proof. And in case of presumption of fact, it is rebuttable, that can be changed by the court, known as. Let us take an example. If a matter came to the court and the provisions of law says that court shall presume, in that case the court accept the fact until it is disproved. And if the provision of law says that it is a conclusive proof, a fact is a conclusive proof of other fact, in that case court will not allow the other party to give the fact which can disprove the other fact, because it is a conclusive proof. Now the provision if says that court may presume, in that case court either accept that the fact is proved or it allow the other party to disprove certain fact. So in that case we have came to know about three sections, basically section 1, section 3 and section 4. In the next video I will talk about relevancy of fact from section 5 to section 55. I will cover some of the sections in detail with case laws. So do not forget to subscribe to inspire me to make more videos related to the topic. I am also making a series on CPC, IPC and how to draft plain or written statement. If you are interested in it, all the links are provided in the description. Now I will meet you in another video. Till then, goodbye.